Welcome to the Business Law, Estate Planning, and Estates Podcast.
Welcome back to the Business Law, Estate Planning, and Estates Podcast with attorney Thomas LaPorte. Thomas is the founder of LaPorte Law Group, PLLC, with an office in Portsmouth, New Hampshire, and a location in Andover, Massachusetts. For more than 25 years, he has guided individuals, families, and business owners through estate planning, probate, and business transactions. I'm Kevin Rosenquist, and today we're talking about succession planning. Thomas will explain how business owners can make sure the company they've built is protected for the next generation. Good to see you, Thomas. Welcome back.
Thank you, Kevin. Good to see you too.
So, I feel like everyone's heard the term succession before, if not for any other reason than the television show. But what is succession planning really for a business?
Yeah, it's one of those terms, much like a trust and other terms that sometimes can be mysterious, but it really isn't. All succession planning is putting together a plan for succession, meaning who is going to take over the leadership of a business, when are they going to do it, under what circumstances, and if there's any payout involved of the predecessor owner, perhaps it's a founder, how is that going to take place? How are we going to fund that? So putting together a succession plan, which can be in a business operating agreement or a standalone agreement. I usually see it as that, and because they're usually developed not at the beginning of a business, but perhaps during the tenure of the business operation, oftentimes 3 to 5 years prior to a predecessor owner wanting to step down. Oftentimes they're family-owned businesses. So the succession plan, how a new owner or owners are going to take over, how that's going to take place, when, and how it's going to be paid for if there is a money transfer involved, usually takes place again when the original owners are getting ready to step down and they want the business to continue. Oftentimes successful businesses are worth continuing. There's a value to them. Mm-hmm. Goodwill's been, or patronage has been built up. So the person who's created that goodwill and value for the business, well, they ought to be compensated for it. So there's various ways a succession plan can be put together. If it's going to be an employee-owned plan where the employees succeed as the owners, well, there's a thing called employee stock option plans. Kind of a little bit complicated, but just another version of a succession plan.
I'm in Colorado. I see that sometimes with breweries. They do like an employee-owned kind of mantra sort of thing. It's interesting. You mentioned the family-owned businesses and stuff. Do you find that small businesses, family-owned businesses are not thinking about this, that they're not prepared for this sort of thing more so than larger companies?
I do see it. Oftentimes the founder of the company, the senior generation, hopes or assumes that son or daughter or the children or one of them or a couple of them will take over the business. But the younger generations have their own mindsets, of course. Mine certainly do. So you can set up a succession plan for the younger generation to take over if they've got the skill sets and the motivation to carry on the business. And if that isn't working out, then the founder or predecessor owner, the senior generation, ought to think about alternatives. Who is the non-family employee who's got the motivations, got the skill sets, the insights, and the desire to operate the company once one retires. So succession plans can be plan A. If not plan A, then plan B. Or they can be put into place once the earlier generation realizes, well, neither of my kids are going to take over the business. Start looking around for who can. Mm-hmm. That might be someone within the company. That could be merging with another company, selling the company, selling its assets. There's various incantations, I think the word is, versions of a succession plan.
You mentioned before, I think you said 3 to 5 years before retirement or whatever that you recommend. Why that number?
Well, I think I say that because by that time, or by that time period, thereabouts, give or take a couple of years, the right person or persons have been identified to be the successors. Uh, that's number one. Number two, usually at that time, 3 to 5 years prior to retirement, my clients at least, and business people in general, I think most of them are planning to start thinking about their own estate plan, to minimize various types of taxes, whether it's capital gains tax, estate taxes, each of which differ in each state. And the family business is part of their estate. It's part of their assets. So the estate planning thought process and the succession planning thought process seem to go hand in hand at about that time period.
What happens if there's no succession plan in place? What are the risks? Like if somebody were to pass away before there's a plan in place, what could happen to the business?
Well, let's talk about the family business, for instance. Well, a person who under the will of the deceased owner, oftentimes a spouse, or if there's no spouse, under the laws of what is called intestacy, meaning without a will, generally the spouse owns the business. And it's very rare. I remember one insurance agency where in this case the widow stepped up, and boy, did she learn the insurance business, and she did a great job. But it was a big learning process. There were a lot of challenges she had to encounter. There was stuff left over from the past that she didn't know about as far as financial obligations, but it's very rare to see that. So oftentimes when the key person is no longer there, the deceased spouse in this example, then the value of the business can be greatly diminished, if not be undermined almost entirely. So identifying key people that can succeed, that know the business, have the motivation to maintain the business and or expand it appropriately or consolidate it, is pretty important to keeping value. And the widow in this example gets the benefit of that value. We can couple that scenario with methods to pay the widow off for her interest in the company, with insurance policies, and generally we can have a payout from available cash. We agree on an interest rate in advance. We agree on a term over which time in this case, the spouse, the widow, gets paid off. She doesn't want to run the business, or he doesn't want to run the business, doesn't know how to, but the key person does. And at the same time, the owner gets bought out over time. And it's a sort of a basic description of a succession plan.
So aside from, passing it on to families or other employees or anything like that, you can obviously sell the business, you can bring it to a buyer. Is that also considered part of a succession plan if the owner decides to go that route?
It sure is. And thank you for asking that question. It was the next thing I wanted to talk about. If within the company or within the family, there's no recipient or potential operator, then a good business person will start to plan and look around for others, perhaps within the industry. Say it's a transportation company who may want to expand, or a roofing company. I just helped a very entrepreneurial guy acquire his second roofing company. He's expanding geographically his marketplace by buying out these other businesses. There could be a general contractor, for instance, that wants to integrate into his or her business or their business plumbing business. I see this with what are called home services businesses now. They provide all sorts of the sub trades under one roof, um, sort of like a modern day general contractor.
Mm-hmm.
Um, those types of businesses are interested in your business and are willing to pay money for that. And it's a third party. Um, and they have the knowledge, they have the skill sets, and they often have the capital, revenue, or the ability to obtain loans, which are their obligations to purchase your business. Um, Oftentimes, these third parties don't want to acquire your liabilities if there are any, so they'll enter into what's called an asset purchase agreement, which if I'm representing the buyer, I tell them, don't buy the stock, don't buy the company, you're buying the assets. That way they don't take any contingent liabilities that may be laying around. For instance, in a construction context, and I'm just using that as an example, there could be claims that there was defective work done in 2 years ago. Well, if
Mm-hmm.
you're buying the company and the stock itself, not just the assets, well, as a new owner, so long as statute of limitations hasn't passed, you're responsible for taking care of that claim.
Yep.
So if I'm representing a seller, I often want to sell everything, assign the rights and the responsibilities. So depending on who you are, um, again, it's pushing risk. Well, I didn't say this, but it's a matter of pushing risk back and forth across the table. So
Does it
having
just
someone
become a
who knows these
negotiation?
things,
Is it just negotiation
exactly.
back and forth?
Having
Yeah.
someone who knows how to negotiate uh, these types of succession plans or deals with third parties um, involving businesses is pretty important. There are business advisors, business appraisers, some tax advisors are good at it, CPAs, and certainly there are many business attorneys that um, know the way around this world. So,
Mm-hmm. Can you talk about buy-sell agreements and operating agreements and how they support a smooth business transition, whatever people choose?
sure, a buy-sell agreement, also known as a cross-purchase agreement, usually involves insurance policies. And say there are three owners. Let's keep it simple. Say there are two owners. Then the company can either purchase life insurance policies on each of them and pay the premiums, or each of the owners can purchase insurance policies on each other's life and be the benefit of that. If one of them passes away, so say, Kevin, you and I are in a business and you have the bad sense to pass away on me early, and hopefully you're in a wonderful other world. Um, I have an insurance policy on your life, and say it's $1 million, for instance. We want to value it, and we can always up the coverage as the business grows. Um, I will receive that money, and I can purchase your interest, the 50%. We're equal partners, for instance. We're equal members in LLC. Whomever is your beneficiary under your will or under the laws of the state that say we do a business in Colorado, you don't have a will, the laws of intestacy say, well, Kevin's not married, but he's got 2 kids. I can buy your 2 kids out with that insurance money. And part of that buy-sell agreement says this is what the price is going to be. Um, Sometimes we don't know what the value is going to be, so we can build into a buy-sell agreement, and the insurance will cover hopefully most or all of the purchase price. We can build in how, at the time of your passing away, your interest is valued, which is 50% of the company. We can use an appraiser. We can use 2 appraisers and average it. There's various combinations of doing that. We can agree on an interest rate if we need to pay your 2 children over time and a term, say 10 years. We can build in provisions that, well, the company's not doing that well, so we'll have 2 months where there's a grace period that a payment does not have to be made. All those are all tools that can be put in place with a buy-sell agreement.
Okay.
And it can
What
be done.
about
It can be done for 3 or more people too. There's just more insurance policies involved.
just more policies? Yeah. Yeah, that makes sense. Are there other financial or perhaps tax issues that business owners need to keep in mind when they're planning for any type of transition?
Well, if there's no insurance, a financial issue, and I just had one of these matters, a financial issue to be concerned about is what is the borrowing capacity of the business? Can it acquire a loan? Sometimes SBA will fund these types of buyouts, but you've got to be creditworthy enough, have enough collateral enough. Oftentimes, if it's, for instance, the SBA, they're going to require personal guarantees and cross collateralization of your home. As far as tax issues go, I always say consult your tax advisor, consult your CPA first. But there are 3 tax issues that come to mind right away. If you're receiving passive income from a buyout in a given year, there could be quite an income tax impact on the seller. Also, if the company was worth 0 when it began and you're selling your interest for $500,000, well, there's a gain there. That's $500,000 gain. And that is taxed as a capital gain. It's not as high as an income tax rate, but it's significant enough. Yep. And also, the selling of that business is providing you with liquidity, which is going to be part of your estate. You're reducing the business to some certain value that's going to be part of your estate and subject to potential estate taxes, depending on what state you live in. And there's also a federal estate tax. Many of us are not subject to it because the exemption amounts are very high, but that's all changing at the end of this year, actually, at the end of 2025. So people ought to get some advice on those 3 types of taxes.
Obviously, we've seen it in the movies and TV about issues, family disputes or whatnot that come up with, or partner disputes, employee disputes, whatever. Do you feel like having a good succession plan in place can prevent these types of disputes between people?
These scenarios, these contingencies are thought of in advance, and the solutions are set forth in the succession plan. There's flexibility to effectuate those solutions, like valuation and buyouts. And people that sign off, business people that sign off, agree in writing on these succession plans are bound. They tend to be psychologically bound because they're affixed their signature to the document. And if a person wants to wiggle away from those terms, well, a court's going to enforce it. So there's a psychological attachment, and then there's a deterrent from not honoring the succession plan, because a court is going to specifically enforce those terms unless it's onerous. But most business people, they have their advisors, and they're going to be considered sophisticated. So long as it's fair, the law won't protect you against bad deals, but again, get some help, but it will be enforced. So it eliminates litigation, which is very expensive, and one of the most inefficient endeavors human beings have ever undertaken. And I'm stealing that from Abraham Lincoln.
So just say no to litigation when it comes to business succession.
Sometimes it's not avoidable, but
right.
You can avoid these types of disputes oftentimes with a decent, well thought out succession plan, which is amendable along the way too.
Yeah. You're not locked in. It's not ironclad. So yeah, you can always adjust.
Absolutely. That's right, Kevin. Yeah.
All right. Well, thanks for joining us today on the Business Law, Estate Planning, and Estates podcast. If you own a business and want to make sure it carries on smoothly when you're ready to step back, visit LaPorteLawGroup.net to learn more. Don't forget to subscribe to our channel. Leave us a review. We very much appreciate it. Thomas, great chatting with you as always. Thanks so much.
Thank you for the opportunity. I appreciate it, Kevin.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.